This video is a follow-up to our art where we were trying to talk about registered survey not being a title. Actually, we're not trying. We're actually talking about that fact that registered survey is not a title. And we got a lot of responses in which people disagreed. Some people disagreed. Some people agreed. And many people in the comment section asked, what is a title? Now, before we continue, let's talk a little about the Land Use Act of 1978. The Land Use Act of 1978 conferred on state governors the authority over land. Now, in that act, it says that governors owed this land on behalf of the state for several state purposes, and as such exercises authority over urban areas, and that local government chairmen or chairpersons will be the persons in charge of non-urban areas. Now, as far as I'm concerned, interpreting it, I'm not a lawyer, but as far as I'm concerned, if you go further in that act, you will see where it says that it is the state governor themselves that can define the status of urban areas. So invariably, the state governor determines, if I might as well say all areas in my land or in my state are all urban. So invariably for me, I believe that the state governors determine how much authority or ownership the chairman of the local government can exercise as regards to holding in trust land ownership in their respective jurisdiction. Now, that said, there are documents that are very important in land transactions. Very, very important. Now, these documents cannot be referred to as titles, some of them. Now, what are titles? Titles are certificate of occupancy, accession or gazette, freehold, and governor's consent. There is a fifth one, or even the sixth, which is court judgment, registered court judgment. We'll talk about that. And also probate and letter of administration. Probate and letter of administration. So let's dig into each of these. We have said that the governors of each state, according to the Land Use Act of 1978, hold in trust ownership of all the land in their jurisdiction, especially to the urban areas, except land that have been designated to be owned by the federal government of Nigeria. To now get land as an individual of a state, whether you are indigent or non-indigent, you have right to land ownership. Follow us, subscribe on our channel so that you can get up-to-date information on all matter real estate. We want to help guide you to make the best investment or purchase decision of your land based on your investment goals. Okay, so let's get back to what we're discussing. Certificate of occupancy. If you want to own land in any state, you have to apply for the title over that land, having completed the land transaction. We'll get to that later. So the title you will be given is certificate of occupancy, where you have 99 years to hold that land. So technically, you don't own a land. You are only holding that land in possession for 99 years, according to the Land Use Act. After 99 years, you have the option of renewing the ownership of your land. Then you have the governor's consent. Now, the governor's consent has two ways to it. One, if you bought land, let's say you are buying land from me, Mr. John Sholari, I have perfected my title of that land and I have a certificate of occupancy over that land. And you are buying land from me. No one land can have more than one certificate of occupancy. One certificate of occupancy is issued by the state government, signed by the governor, and put under registrar, in the registrar with the Ministry of Registrar. That's the land registry. Okay? Approved also by the registrar of titles of that state. If I sell that land to you, I've been given 99 years over that land. Now, if you buy the land, you need to perfect that title in your own name. So what will be issued for you will be governor consent. That is a secondary title to my own primary title, which is what? certificate of occupancy. So let's say Chibuzo is buying, Mr. Chibuzo is buying from Mr. Sholari, and what I have is certificate of occupancy. Mr. Chibuzo has to get a governor consent on that land, provided I had not exhausted my 99 years given to hold in possession of that land. So the governor consent will now cover the number of years the remaining for that certificate of occupancy to expire. Now, that is that about governor consent. Let's go down to excision and gazette, and as it relates to governor consent. Now, excision is just a parcel of land excised from the word, excision, by the government under government acquisition, primarily under government acquisition. Remember, we said the Land Use Act basically confers land ownership on the governor to hold in trust as the authorized owner of all land. Is holding in trust on behalf of the state or on behalf of the people, the citizens of the state. Now, usually, this power is exercised to make sure that there are lands for public uses. So where certain lands have been acquired, we call it acquired land, where certain land have been acquired by the government for the use of the public, the governments also have the prerogative to excise this land to a family, an individual, or to a community. Most of the time, excision is given to a family, a community, or corporate organizations or entities. Now, where such excision has been publicized in government register or record, we call it a gazette. So if as an individual you buy a land that has been excised but not yet gazetted, when you want to perfect the title of that land, you get a certificate of occupancy, your 99 years. But if it is already gazetted, right, that is by law, this excision holds to whomever it has been issued to. If you as an individual buy that land, then you will be getting a governor consent. So you see, usually governor's consent is a secondary title. It's always a successor, so to say, to an initial title, usually the primary title. Then we go to freehold. Under the Land Use Act of 1978, it recognizes also customary ownership. Ownership of land by usually the aboriginals of a place or the early settlers of the place. So freehold is usually given or recognized to or for families or communities that are initial settlers in that place. Okay, so let's talk about the two remaining titles. Number one of the two, probate or letter of administration. So they both go hand in hand. Now, probate or letter of administration is given to the heirs or relative of a deceased property owner where there is a will, so to say, or where there is no will. Working with your lawyer, you can get probate or letter of administration from the state to claim legal owners or rightful owners of the land. But that is dependent on if the land in question has proper title in the first instance. What that means is that whether you want to claim probate or not, it must be that that land already exists in a non-acquisition land or no form of government encumbrance on it. The person whom you are claiming the probate over his property has rightful title over that land according to the laws of the state. Let's go now to court judgment. Ordinarily, ideally, let's not even say ordinarily, ideally, a registered court judgment over a land should be the most important, irrevocable title over any land in the state. If there is a registered judgment in a court, ideally, the title of that land should hold. Like I said, so that is that about title. You can give me a call if you want to know more, or send DM if you want to know more. But it is very important that you follow or subscribe to our page so that you can get up-to-date information, educational sessions on your property investment. I remain your trusted and efficient realtor, John Adegbenga Sholari. Thank you.